Hello everyone, welcome to the Law of Torts lecture series. In this video, we are going to talk about trespass to property. But before talking about trespass to property, let me introduce you that as in what are the concepts we are going to cover in this video. So we'll start with very basic understanding that what amounts to trespass and what is trespass. Then I'll explain you that how trespass is different from nuisance. Then I'll talk about that what is the definitional difference of the understanding of trespass to property in criminal law and how it is different from tortious liability. Then trespass ab initio concept, which is very important concept under trespass to property, will be explained. And through case laws, we are going to decide the journey, the development of trespass to property. Now starting with what is trespass, the basic idea, the basic understanding of trespass is to go on someone's property. Now to go on someone's property is trespass is a very vague definition of trespass. Why? Because there could be a possibility that out of necessity you are going to someone's property. So to understand, to make myself clear about the definition of trespass, I have referred Black's Law Dictionary, 6th edition, which talks about trespasser, and trespasser is someone who trespasses. And what is trespass? Trespass is that tort where person intentionally doing something which he has not taken the consent or the privilege from the possessor. That means if I am entering someone's property intentionally and I have not taken the consent of the possessor, or I do not have any privilege regarding it, and if I am entering to that property, I am doing trespass. Halsbury Law of England also defines trespass, and it says that every unlawful entry by one person on the land of another is trespass. Why? Because in trespass, we generally need not to prove that damage has been occurred. That means trespass is different from nuisance. Why? Because in nuisance we have to prove that the damage has been suffered or is likely to be suffered. So this is the first difference between trespass and nuisance. Why? Because in a way they both have similarities, and similarities with regard to what? Similarities as in they both are taught in as in they both talk about the infringement of someone's property. But trespass is per se tortious in nature. That means if you have entered into someone's property, no matter you have not committed any wrong, or no matter you have not sustained, the possessor have not sustained the injury, you are being held liable for trespass. But trespass is more direct in nature as compared to nuisance. That means in trespass you are directly affecting someone's right. But in nuisance you are consequentially or indirectly affecting someone's right. For example, I'll explain these two concepts with the help of an example. For example, if someone is entering to your property, here he is directly challenging your right to your property. But so for example, if my neighbor has constructed multi-storied building, and because of that building I could not be able to enjoy the sunlight. That means I could not be able to enjoy my property. Now this is what? This is consequentially affecting. The high-rise building is indirectly affecting my right. Okay. So this is the basic difference between trespass and nuisance. Now moving further, in section 441 of Indian Penal Code, trespass has been defined. The section 441 of IPC defines criminal trespass, and it says that Under the definition it says that whoever intentionally entering someone's property. So here the basic difference, the first difference and the most important difference between trespass under Indian Penal Code and trespass under tortious liability is intention. That means if you have to prove that someone has trespassed to your property, you have to prove that there has to be a guilty mind. Okay, because the basic understanding of to constitute a crime, there has to be actus reus plus mens rea, and this mens rea is what? Intentionally doing, knowingly doing. But what about in law of torts? Generally in law of torts we do not consider mens rea or guilty mind. That means if you have not taken due care and by mistakenly entering to someone's property is trespass, if not in criminal law, surely in law of torts. That means in law of torts, now we'll talk about that under what are the cases where one can be held to have been committed trespass. Now trespass could be done to the body, that means what? Assault and battery. Trespass could be done to the property, which we are going to talk about today, and trespass could be done to the goods, as in conversion. Now here in this video we are going to talk about what? Trespass to property. Trespass to property, the basic understanding of trespass to property is if someone is entering to your property without the reasonable justification, that person has committed trespass. Now the word justification is very important here. Without the justification, that means if you have proper justification, reasonable justification, then you will not be held liable for trespass to property. Now what are those justifications? For example, if and how the justification could not be able to work, as in there are cases where, for example, in Pereira versus Vandia, in this case the occupier, the owner, the possessor has invited the guest and he has given permission to the invitees to stay at the guest room, but one person entered to the bedroom of the possessor. Here, the moment he entered to the bedroom, he has committed trespass, no matter he was invited to the place of the possessor, because for the simple reason that the possessor has not given permission to enter into his or her bedroom. Now the second case is Madhav Das versus and B.A.LL.B Das. Now in this case, Madhav Das Kodwa, here the court said that justification could be, for example, if I am owning the property and my tenant is in the first floor and he has to use the compound to enter to his house, and if he is entering to the compound, I cannot say that he has trespassed to the property. Why? Because he has proper justification, and his justification is that without entering to the compound he could not be able to enjoy his property. That is why it is not trespass to property. The third example would be B.A.LL versus Clarkson. As I have already talked about that, in law of torts, intention does not really matter, and in Indian Penal Code, how it is different from IP criminal law is that there they consider intention, because to prove a crime there has to be mens rea, which is very important, but in law of torts we generally do not consider mens rea. So in this case what happened is mistakenly Mr. Clarkson has trespassed to the property of B.A.LL, and basically the fact of the case is this is the property of B.A.L.B, and this is the property of Clarkson. Clarkson, while doing the cutting of his crop, mistakenly he has cut crops of B.A.L. Now, mistakenly he has done it, but even then this is trespass. Why? Because in law of torts, mistake does not really matter. He has to take, he failed to take due care, and if there is no due care, that means this is trespass. Now, in here, after this tortious liability, we'll talk about trespass ab initio. Trespass ab initio means if someone is entering to your property and that person has been authorized by the law, and if that person entered to your property and did something which was not authorized by the law, then that person would be considered trespasser from the beginning. This is the concept called trespass ab initio, where ab initio means from the beginning. From the beginning. Trespass ab initio concept is basically, if suppose for example a constable or a policeman comes to your property to arrest you, and instead of arresting you, they started seizing your property, then this is what? This is trespass ab initio. That means that no matter they are being authorized by law to enter to your property, but what they are doing is not authorized by law, and that is why it will be termed as considered that they are the trespasser from the beginning. But this concept, trespass ab initio, has been discussed in 6 carpenters case. What happened in this case is, for example, the 6 people entered to the restaurant and they ordered food. After having food, Mr. S, one of the carpenter, he ordered another meal and they did not pay for that meal. Now, the question arose that whether this is trespass ab initio. The court said no, this is not trespass ab initio. Why? Because of 2 things. Number 1 is, they have not been authorized by the law but by the private person. As this hotel is not government hotel and these carpenters are not government authorized people, so entering to someone's private property by the consent of the private person is not trespass ab initio. Number 2, because they have not done any positive wrong. That means what? They have not done any misfeasance but just non-feasance. Non-feasance is not doing anything. For example, here they did not pay anything. So this is non-feasance, and non-feasance would not amount to trespass ab initio, and that is why they are not being held liable for trespass ab initio. Now, in Elias versus Passmore, the 2 constables entered to the property of Passmore and they took some property, some right property and some property which they are not authorized to take. They have seized the property. So basically they have seized the property, and the property consists of those property also which they are not being authorized. Now the question again arose that whether this is trespass ab initio. The court said no, this is not trespass ab initio to the property that they have rightly seized, but that would be trespass for the property which they have wrongly seized. Okay. Now with this, let's jump to the next issues. The next issues would be, now if this is trespass, now there has to be a justification, because this justification word is very important. Okay, for example, there could be a possibility that I am being given license. For example, you went to the cinema hall and you took the ticket, and afterwards, while entering to the cinema hall, you are being stopped by the owner, and they said that now if you will enter, you will be termed as trespasser. what to do. Here, the justification would be license. The moment you have purchased the ticket, you got the license. And license are of two kinds: license, bare license, and license with grant. Now, when you bought the cinema ticket, the ticket is licensed as in grant, and those cinema people cannot throw you out. Okay. Number two example, the second example would be, for example, if I have planted a tree and the branches are going to my neighbor's place. Now, obviously, this is trespass or nuisance. This could be nuisance if only the branches are going to my neighbor's place. And for example, if I have placed a seedling in the property of my neighbor, then this is trespass. For example, if my tree's branches are going to my neighbor's place, and because I have taken the license, that means I have taken the permission of my neighbor to cut those branches, and for cutting those branches I need to enter to my neighbor's property. Now, if I enter to my neighbor's property, he cannot say that I have done trespass. Why? Because I have the license, and the license is what? The consent. Okay. Now, after this, let's talk about the defenses. What are the defenses of trespass to property? Now, the first defense of trespass to property is obviously justification. And justification would be, yes, the justification which we have just talked about is license. Suppose there could be a possibility that I have justification. For example, two of my household caught fire, and this is at this point of necessity, I rushed to the door of my neighbor and pour some water to his or her house. Now, no matter I have entered to his or her property without his consent, but whatever I am doing is out of necessity. And if I could be able to justify that I am doing this out of the necessity, then this is necessity case, and this will be dealt separately as a defense, general defense, and not held down as trespass to property. Another example would be private defense. What if out of my private defense I am doing certain acts whereby I need to trespass the property of someone's? Even then, this is a good defense of trespass to property. Now, what are the remedies available for the trespass to property? Now, the first remedy would be obviously very basic remedy. Re-entry is the first remedy. Re-entry means if someone has dispossessed you from your property, then you could obviously appeal to this. You can file a suit against that person, and the remedy would be the court will order to that person to re-enter you, to give you re-entry to your property. Now, second would be ejectment. Obviously, re-entry is one of them, but ejectment means if I want to eject someone from out of my property, I can file a suit again and I'll eject that person out. Third would be obviously if, for example, my tenant has not given me rent of 6 months and wrongly possessed my property, then the court will ask the tenant to give the mean profit or the average rent to me of those 6 to 8 months. So this is another remedy available in the court. With this, we have done the trespass to property. I hope you got the concepts right, and if